Hi everyone, welcome to Thorough Newspaper Analysis. This is the video for the 22nd of May 2024. Now let's quickly proceed and have a look at the pointers of discussion for today. So in the first segment of editorial, we have an Indian Express article to discuss. See, essentially this article deals with a law that was brought about by the state of Gujarat to address the problem of land grabbing by land mafia. This law was challenged before the Gujarat High Court on dual grounds, and the Gujarat High Court has sustained the validity of this law. So we'll understand what are those two grounds of challenge and a couple of other aspects about this law. Secondly, we talk about the news updates, and this is going to be followed by the last segment of legal news, where we have two updates from the Honorable Supreme Court. So without further ado, let's start with the article and let's first have a look at the title of it. What is Gujarat's land grabbing law and why has the High Court dismissed the challenge to it? So before we start with the context and the important provisions of this law, let me give you a brief picture of it and let's just zoom out on this article so that we understand the important, the bigger picture here, so that we'll be in a position to appreciate the nuances of it better. See, this government of Gujarat, based on certain reports which were presented before it, noticed that there was a problem in the state. The problem was the grabbing of lands of farmers by land mafia. The government realized that although there are a couple of other statutes, other laws already in place, which, touch upon this matter, but there is no full-fledged law addressing this problem. So the Gujarat government in December 2020 came about a law by the name of Gujarat Land Grabbing Prohibition Act. Now, this act was challenged before the Gujarat High Court on two grounds. One was that the president's assent was not taken. Now, why was the assent of president required? Because it's a state law. So that we'll understand in just a bit. And secondly, that this act was manifestly arbitrary. It was vague and hence its constitutional validity should not be upheld. So now let's understand the context. See, the Gujarat High Court has upheld the constitutional validity of this law, which is the Gujarat Land Grabbing Prohibition Act. And this Gujarat High Court did so while highlighting and underlining legislative supremacy over judicial review. The law brought into effect from December 2020, it retrospectively criminalizes land grabbing of both public as well as private properties. Secondly, it reverses burden of proof. And thirdly, it prescribes minimum sentence of 10 years for violations. So as you can see here also, the sentence term, it is very high. It is, equivalent to some of the grave offenses under the IPC. So minimum, and that too, this is the minimum sentence of 10 years. The burden of proof, it is reversed. And there is a retrospective application of this act. Now let's understand some of the important provisions and let's first see the statement of object of this act so that, we understand the intent of the legislature in enacting this act. So the law to prohibit land grabbing activities and connected matters in the state of Gujarat, it is aimed at ensuring a time-bound and speedy disposal of complaints and to protect the interest of farmers and common man. So what are we targeting? The government wanted that all the complaints that have been, put forth by farmers or the common man owing to the grabbing of his or her land, those complaints should be speedily disposed of and should be dealt with in a time-bound fashion. Accordingly, the state government, according to the state government, the law was brought not only to declare land grabbing as an unlawful activity, but also to prohibit the offense. This law, it essentially replaced proceedings under the existing legislations like the TPA, the Transfer of Property Act, and the Public Premises Eviction of Unauthorized Occupants Act of 1971, and brought the offense of land grabbing under a single special legislation. Crucially, this law, it is applicable retrospectively. So by retrospective application, what do we mean? It means that it can change what was legal or illegal before the law came into force. and it contemplates both civil and criminal action. By retrospective application, we mean that suppose, let's say there is an act which was committed in January of 2024. And at that point in time, the law that our country follow, it did not say that, this act is an illegal offense. This act is an offense. There was no declaration of any sort in any law. But later on, in March of 2024, there comes a law which says that so-and-so act, it is an offense. And this act is going to take effect from December of 2023. So then that means that it is retrospectively applicable now. Apart from eviction, it prescribes a minimum punishment of 10 years. This we've already noticed that there is minimum prescription of 10 years in jail, which can go up to as high as 14 years, and also a fine which is equivalent to the revenue value of the property concerned. Now, there is a section 11 in this act, which provides for reversing the burden of proof. Let's understand what does this mean. See, it essentially means that on a prima facie allegation, which is made by, or let's say, the person or the farmer whose land has been snatched. So if the farmer makes a prima facie allegation that Mr. X has grabbed my land, then the special court shall presume that the person who is alleged to have grabbed the land is indeed a land grabber, and the burden of proving that the land has not been grabbed by him, it shall be upon such person who is placed under that allegation. By shall presume, we mean this is a concept of Indian Evidence Act. Section 4 of it, it defines the types of presumptions. Shall presume, may presume, conclusive proof. So shall presume essentially means that the court is going to presume the fact which is alleged, and court cannot on its own volition ask for proof of it. It is upon the other party to rebut this presumption. So there is an option with the other party to rebut the presumption, but the court on its own cannot call for evidence, which is the case in may prove. Now, the shifting of onus on the accused to prove that he has a valid lawful entitlement to the property, it is departure from the settled law, which states that even a squatter can be dislodged only in according to the principle of due process. Let me explain this para. See, it essentially means that this reversing of burden, it is taking a departure. It is deviating from a settled position of law. What is that settled position? You must have come across this while you must have read SRA section 6 and section 5. So it is essentially saying that it is the settled law which states that even a squatter is somebody who has entered into another person's land and, let's say resided there without the permission of that person. So even a squatter cannot be dislodged from the property without following the due process. Let's say there is a trespasser. He has entered into my property and he's been living there for, let's say, a couple of months. And he has used my property for he has put my property to its natural use. So this person is going to be said to have settled possession. Settled possession is when you're enjoying the possession of a property for a considerable period of time, and you've put the property to its natural use, and you also had the intention of exclusively enjoying the property, and you've done something towards that. So there's animus, there's corpus, and you're in settled possession. You were a trespasser, but now you've lived on my property for a considerable period of time. Now, the person, the real owner, has a remedy under section 6 of the SRA. So within 6 months of, let's say, the dispossession, you have to file the suit and so on and so forth. So here what we understand is that even a squatter, a trespasser, cannot be removed without following the due procedure. You cannot bring goons and, remove the person. So that is what it is saying, that this is a deviation from this settled law, because here the burden of proof is placed on this person who is put under the allegation. Now let's understand what are the challenges against this act. So the challenges are twofold. One is the procedural challenge, which is the violation of procedure of the constitution law, which is the requirement of seeking assent of the president. For this, we'll make a reference to Article 254 of the Constitution. And secondly, substantive ground. Second challenge is on substantive ground. It states that the law, it is vague and it is manifestly arbitrary. Let's understand presidential assent. On the procedural aspect, the petitioner argued that since the state legislation, it is repugnant to several central laws. Therefore, it requires the assent of the president. Now, why is the state legislation repugnant to the central laws? This is because of Section 15. Section 15 gives overriding power and effect to the provisions of this act, this land grabbing law. What does it say? It says that the provisions of this act shall have effect, notwithstanding anything which is inconsistent contained in any other law for the time being in force. Suppose there's a TPA, a central law. Now, there is a provision under this 2020 Act, and the TPA provision, they are inconsistent to each other. Then which law is going to prevail? The 2020 law is going to prevail as per Section 15. So therefore, the advocate representing the petitioner here, he argued that a special law that is repugnant to the general law applicable to the field would require presidential assent to be valid. In order for a special law to be valid, when it is inconsistent with a general law, there has to be presidential assent. This was the argument of the council. And for that, he made reference to Article 254. So what is Article 254? It prescribes the procedure to deal with inconsistency between laws which are made by the parliament, so a central law, and made by state legislature, a state law. So when a state makes a law which is repugnant, which is inconsistent to a subject in the concurrent list, where both the union and the state can make law. So there is a union law, there is, let's say, a subject in the concurrent list. Now, with respect to this item, this matter, this subject, the central government has already, the parliament has already made a law, and the state has now made a law. The provisions of the state, they are repugnant to the center. Then it can be applicable only if it has been reserved for the consideration of the president and receive his assent. Now, about concurrent list, this is an information pointer. You may make a note of it. So it is taken from Australia. The source of concurrent list in our constitution is the Constitution of Australia. Now, such assent, it has to be received in advance and not after the law has been made applicable. So to give you an example, recently, we know the Uttarakhand legislature, it brought about the UCC. So UCC, it received presidential assent. Why? Because there is an entry, which is entry number 5 in the concurrent list, and it deals with marriage and divorce, succession, and connected aspects. So which means both the state and the center can make law with respect to entry number 5. And there is a UCC which is brought about by the state government. So here the presidential assent was received. Now in the present case, criminal law and transfer of property, these two matters, criminal law and transfer of property, these two matters are dealt with by the 2020 law, correct? Because it criminalizes this activity of land grabbing and also it deals with the transfer of property. So these two items, they are covered with entry number 1 and 6 respectively of the concurrent list. These were the arguments of the petitioners' council. Now the High Court, ruled something else. High Court did not find substance in these arguments. High Court rather applied the doctrine of pith and substance and came to the conclusion that when the essence of the act as a whole was examined, then it could be determined, or the court came to the conclusion that this Gujarat land grabbing law, it actually deals with entry 18 of the state list, which deals with land. So it falls under the state list. Therefore, this argument on procedural ground violation, it was discarded by the High Court. Now let's talk about the second ground of manifest arbitrariness. So see, currently for a law to be, to sustain its validity, the test of Article 14 is arbitrariness. That is the new test, right? So here we need to understand whenever manifest arbitrariness has been contended, then this has to be satisfied. That a lack of intelligible differentia and a reasonable and logical basis for classifying individuals into distinct groups for the purpose of legislation, they are grounds for striking down a legislation on the basis of manifest arbitrariness. So if you want to sustain your argument of manifest arbitrariness, what are the two limbs that you have to prove? That there is lack of intelligible differentia. The classification that you're making in two groups, It is not based on intelligent, differentiable, or reasonable grounds. So there's intelligible differentia and a reasonable and logical basis. There is a lack of reasonable and logical basis for classifying individuals into distinct groups. The classification of people or group, individuals that you've prepared, this classification is not based on reasonable or intelligible differentia. So the petitioners here argued that clubbing private complaints on encroachments and grabbing of public land, these two are distinct groups and they cannot be treated alike. Why? Because private complaints could originate from succession and partition suits also. Crucial to the application of the law is the broad definition of land grabbing itself. The law, it defines land grabbing to include the act of occupying, or even if there is an attempt to occupy with or without the use of force over any land, be it government or private, over which he or they have no ownership, no title or physical possession without any lawful entitlement. The term lawful entitlement is not defined, and hence it raises questions on whether adverse possession would be considered lawful entitlement or not. Now, under the limitation law, a non-squatter after 12 years will be entitled to ownership of the land in case of private property, and in case of a government or public-private property, this limitation period is 30 years. And this is the concept of adverse possession, which is dealt with, I believe, under Section 27 of the Limitation Act, which provides for the law of prescription. So here, not only your right, but not only your remedy, but also your right is extinguished. Adverse possession, a settled area of law, also ensures that there cannot be retrospective application of law. The Gujarat law, it is silent on this aspect. The High Court, however, held that the law cannot be said to be retrospective in nature, since the offense of land grabbing, it is a continuous one, and therefore it continues therefore, if he continues to be in possession, it is a continuing act. The act of land grabbing, it will be considered to be a continuing act if the person, squatter, is continuing to be in possession of the land. The enactment works as a deterrence, simply sending a message that all those who have occupied someone else's land, whether owner is government or public body or it is a private person, shall have to hand over the possession or vacate the grabbed land to restore possession to the rightful person, or else they will be considered as land grabber and criminal proceedings shall be initiated against them. This is what the court said, reflecting upon, the positive impact that this particular law is going to bring about. Further, on the reversal of burden of proof, the court held that while the accused or the person against whom these allegations of grabbing land have been leveled cannot remain silent on such circumstances. Why? Because onus to speak to prove his lawful entitlement to the land in question shifts on him. So naturally, he's going to come forward and present his case. He's not going to remain silent. And with this, we proceed to the national news category, and this is the first update here. Coal India, NMDC, ONGC, Videsh, they seek overseas critical mineral assets. So the Indian government has announced its plans for public sector companies or PSUs like Coal India, NMDC, and ONGC Videsh Limited to actively seek critical mineral assets overseas. These PSUs, they are set to explore critical mineral assets abroad under the guidance of a group of secretaries. These PSUs, they are already established players in the international market, and they're well positioned to expand their presence in search of essential mineral resources. This particular move, it aims to secure vital mineral resources which are essential for various industries, including clean energy technologies and electric vehicles. Government-backed ONDC, it attracts 10 unicorns and 125 startups. The Open Network for Digital Commerce, ONDC, which is backed by government, it has garnered significant interest from key players in India's digital ecosystem. Let's understand or have a look at some of the key players who've shown its interest. So these are Zerodha, then we have Ease My Trip, Cars 24, thereby signaling a strong push, in fact, towards democratizing digital commerce. Gopi Thotakura, he's an entrepreneur and a pilot. He's become the first Indian to venture into space as a tourist aboard Amazon founder Jeff Bezos' Blue Origin's NS-25 mission. This is a very, very important update. Please make a note of his name. He has become the first Indian to venture into space. Why and what is this mission? So he's going to venture into space. He's going to get into space as a tourist as part of the Blue Origin's NS-25 mission. He was selected as one of the 6 crew members for the NS-25 mission, thereby making him the first Indian space tourist and the second Indian to ever venture into space after Indian Army's Wing Commander Rakesh Sharma did it in the year 1984. Indian Army reduces ammunition import. The Army is now indigenously sourcing multiple types of ammunition for tanks, artillery guns, rocket launchers, multiple grenade launchers, multi-barrel rocket launchers, among others. The development of several private sector indigenous industries along with the existing public sector firms, it has helped in an increase in the production of ammunition within the country. And as a result of this, the government and the country as a whole, we can, then strike at reducing the imports, because at home we have other sources to meet our needs. Now, this has brought us to the international segment for today, and we have an update in the category of sports. Premier League, the update is with respect to this. Manchester City becomes first team to claim 4 consecutive titles. Manchester City has created history by winning the 4th consecutive English Premier League title with 3-2 win over West Ham. World's first 6G device launched in Japan. A Japanese consortium has unveiled the prototype of what is said to be the world's first high-speed 6G device, promising data transfer at lightning speed. Now, this has brought us to the segment of important days for the day, and this is the World Metrology Day. Please make a note of the concerned date here, which is 20th of May. So the World Metrology Day, it was observed this year on 20th of May. Let's understand its historic significance and how has this day come about. So in the year 1875, with the signing of the Meter Convention, the International Bureau of Weights and Measures was established. Now, what is the utility and the function of this bureau? See, this bureau, the BIPM, the International Bureau of Weights and Measures, it is an organization which is focused on promoting the uses of a standardized measurement system. Following the establishment of this and its functioning, which is focused on promoting such uses, this led to the development of international prototype of kilograms, which is now the standard unit of mass, while international prototype of meter, it was chosen as the standard unit of length. The World Metrology Day, it was celebrated for the very first time on 20th of May this year. So 20th of May, this was celebrated for the very first time for this day. Now, continuing with the international news segment, we have an update from Iran. So Iran's president has passed away. So India has announced a one-day state mourning. India announced this as mark of respect for the Iranian president, Ebrahim Raisi, who died in a helicopter crash. And as part of this crash, in the incident of this helicopter crashing, apart from him, the foreign minister for the country of Iran also died, along with 7 other officials. Satwik-Chirag, the duo, they've won the 2nd title of 2024. The world number 3 Indian badminton pair of Satwik-Chirag Reddy and Chirag Shetty. They won the Thailand Open 2024 badminton men's double title, and they've done so. They've secured the win by defeating their Chinese counterpart on 19th of May 2024. This is an important update. Thailand Open 2024 badminton tournament men's double. This title is now secured by the world number 3 pair, which is Satwik-Chirag Reddy, and then we have Chirag Shetty. They won this. The Indian pair defeated world's 29th ranked, their Chinese counterpart, and this happened in Bangkok, Thailand. With this, we come to the legal news update segment, and the first update is from the Honorable Supreme Court. So the Supreme Court, in the case of Preeti Agarwala and others versus the state of NCT of Delhi, this should be NCT of Delhi and others. So the Supreme Court is now, while deciding a case arising out of a complaint made for an offence under the SC/ST Act, which is the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act of 1989, observed that an allegation of insult has to satisfy the requirement of having been made within public view. So see, under the SC/ST Act, there are certain requirements. Let's say if you want to invoke the provisions of this act, and if you want to say that certain person has, made certain casteist remarks, or there's casteist slur which is involved here, then there are certain requirements. And one of the elements is that this person must have made this casteist slur in public view. So somebody must have heard this particular casteist remark. So the Supreme Court has underscored the uses of the phrase in any place within the public view, which is used in a section of this particular act. And the court said that this must be made within the public view itself. Bail can be cancelled by same court which granted it if there are serious allegations, even if accused hasn't misused the bail. So this has been held by the Supreme Court in the case of Ajwar versus Wasim and another. So the Supreme Court has observed that the same court which granted bail to an accused can cancel the bail if there are serious allegations against the accused, although the accused is not misuse the conditions of bail. So please note, the Supreme Court observed in this particular case that if there are serious allegations against the accused person, then even if he has not misused the bail granted to him, such an order can be cancelled by the same court that has granted the bail. Apart from this, the Supreme Court also said that a higher court can also revoke the bail. Now, what are some of the considerations that the higher court must keep in mind? What are some of the pointers? So first is, if it transpires that the courts below, they've ignored the relevant material available on record. First is this. Secondly, the court below has not looked into the gravity of the offense. And thirdly, the nature of the offense is such that the impact on the society, it is severe. So there is a societal impact also resulting from such an order. So now this has brought us to an end of our TNA. Thank you so much for watching. Have a wonderful day ahead.